welcome back. And as we mentioned earlier, we're going to be talking about the International Day for Intellectual Property, which is marked on the 26th of April, and it's celebrated worldwide. And we're glad to be joined today by Mrs. Nadia Adri, manager of a copyright company in the Middle East, and Mrs. Mona Dagher, patent manager. And we're delighted to be joined by both of you. Good morning to you to shed more light on this issue.
A very good morning to both of you. And first, why was the 26th of April chosen to be the International Day for Intellectual Property?
Because the member countries of WIPO has designated this day to be, which was the day of the WIPO Convention came into force, to be the intellectual property around the world, to celebrate this day, to encourage the intellectual property and harmonize the local laws to be as one, in order to have a full protection for the intellectual property, which covers trademarks, patents, industrial designs. In this connection, SMAS-IP has celebrated this date with the Arab League on 22nd and 3rd of April in Cairo. So in order to introduce the challenges which have been are facing the intellectual property in the Arab countries, in order to have more harmonized achievements and progress in this matter.
Yeah. Right. How is the International Day for Intellectual Property celebrated worldwide, and how is it celebrated here in Egypt?
Or marked, at least.
Yes.
But I think that not everybody knew about it.
Right.
The title of the Intellectual Property Day in the World International Organization for Intellectual Property is to get up for music. It's essentially nowadays 2015 for music. So worldwide celebrate the...
So the music was the theme of the day.
Yes.
Right.
Because music is protected under the copyright protection. So WIPO celebrate music nowadays. And worldwide, each country celebrates in IP Day. In Egypt, SMAS with the Arab League celebrate the Intellectual Property Day, and it's a beautiful and very powerful day.
And you were speaking about challenges which are facing whether the intellectual property protection and patent protection in the Middle East or in the Arab region. Are there different between what's going on here and worldwide? I mean, do we have something in common, or whenever we are speaking about developed countries, it's that much different than the developing ones?
WIPO has member countries are a party in several conventions and agreements, such as Paris Convention, Berne Convention. Paris Convention is related to industrial property, which covers patents, trademarks, industrial designs. Berne Convention covers copyrights and related rights, copyright and performance. So these conventions and agreements give the main points of the protections, which the local laws should have, the local laws should have the main laws and articles in their local national laws in order to be enforced by the courts and in the local practice.
Right. What are the mechanisms by which you work, to accomplish your mission? How do you protect copyrights? How do you protect patents and so on?
First of all, to registration for each. For patent, as example, you have to keep your invention secret until you file the application with the patent office. This patent have a long period for protection. It's 20 years, and from filing to registrations take about 3 to 5 years. It's a long period, but it's
and why is it taking all that time?
Because of examination. Patent is a new solution for a technical problem, not as a trademark, as a logo or something discourage the company. It's about technical solution, new technology. A patent around us, electrical light, to tools in the kitchen, and nanotechnology chip. It's around us, but it's take more time than other types of intellectual property, but it's investment.
At least on the long run.
Yes.
If
Yes.
you may say so.
Yeah. What about the dangers of imitating copy or copying certain products? What are the dangers facing those who do the copying?
Yes, this is what the problem which the owners of the trademarks and the industrial designs which faces and patents. The consumer may sometimes are not aware that the product which they buy are counterfeited or not the original product. You buy a certain product with a certain trademark. You are interested in the trademark for its quality, for its source and origin. So when you buy it, you are buying it for the title which it bears and for the quality of the same. But sometimes the consumers are surprised that the product which they bought is not original, it is counterfeited. So it may affect their health, it may affect their safety, and in other aspects of life which they might not be aware when they purchase the product. So it's the role of the administrative offices in the country and customs.
But this is taking place all the time. I mean, major products, major brands are being imitated, and I don't think this is with any license.
Yes, in order
Maybe because the punishment is not that tough?
no, most of the intellectual property have civil protection. IP firms usually are, and trademarks and the intellectual property owners are trying to stop this infringement action by notifying the officials that there are some certain products which may enter to the market which are counterfeited. And especially with the custom, it's possible in some countries to file an application, register a trademark, so the custom may examine any product which may hold this trademark to stop it from entering the market before it is may cause any damages to the local consumers and to the owner of the trademark.
Yeah. I don't know why it was really for me a shock that to know that when I want to register an invention, it should take from 3 to 5 years or something.
Yes.
How are you going to deal with the new inventors, the newcomers, I mean the youth, who would feel, I think, even frustrated when they know that the invention is not going to be registered under their name except after such a long time?
This is one of the most challenges today, this long time to registration. But worldwide, it's 3 years, worldwide. Okay, in our Arab world, it's from 3 to 5 years. Okay, so infringement punishment is not enforced. Is punishable only after registration. So when infringement is before registration, it's a very big problem. But okay.
Okay, let's be more frank.
Okay.
Do you think that bureaucracy is playing a role here? And if there is something to be eliminated as an obstacle, what is it?
What is it? It is an examination process. Examination process takes more than 2 years in the best cases. 2 years, because it is a technical issue and it is a negotiation between the patent office and the inventor to protect to narrow the protection period, to narrow the protection boundaries, and to narrow the protection of the invention, as because this may be beyond the protection right of the owner. Okay, so it take more time, but the investment is very high, and the protection period is 20 years. This is a long time. A trademark is about for long, it's forever, but for patent, because because patents after 20 years enter into the public domain. This is make development in the technology, because it's about the public domain. Third party, anybody can use and sell and make this invention without the authority approval from the owner after 20 years.
Right. What's the Paris Agreement to protect the industrial copyrights? That was an agreement that was signed, I think, in Paris.
Yes, it was signed in 1883. It is for industrial property, which covers patents, industrial designs, which geographical indications, and trademarks. For copyrights and related rights, a separate convention was signed with Berne Convention, which is separate rules and separate articles which grants the protections with detail to the owners of the copyright. So it's mentioned that copyrights do not require to be registered to obtain the protection. It is by once it is the material is produced by the owner, and the idea and arrangement of the idea is out to the public, so it is already protected. Usually the owners register it for more confirmation of their rights in relation to the copyrighted material, but for example, contrary to the trademark, you are not owner of the trademark unless you register it with the trademark office in respective of each country.
Please, ma'am, correct me if I'm wrong.
Okay.
Whenever I'm talking about a new medication, for instance, that one which was newly introduced to the Egyptian community to treat virus C, should it take first permission or a license from the patent office?
Yes, please again the question in other words.
A medication, if a new medication is
Okay.
going to be
drug,
introduced,
yeah.
a drug,
Yes.
should it take first a license from the patent office?
If the new medication is honored for patentee.
Okay.
In that case, you have to grant a license from patent office, grant a license from the patent owner for first, and then recording this license in the patent office in order to be free to use and sell and make the new medical or new drug.
Yes, but it should be novel. It
Yes.
should be new to the something new
Okay,
to the drug.
I was talking in specific about the Sovaldi.
Yeah, okay.
Okay, because I knew that this was a very important issue and a very important hope for more than 14 million Egyptians who are suffering virus C.
Yes.
How have you, for instance, dealt with such a vital issue?
For first, the Egyptian manufacturer of the Egyptian factory firms have to take a license from the original factory outside. Okay, this is for first, and then it's free to work without the authority.
But it will not take such a long time.
No, because Salvador is very public, and it's not a novel, it is not a new invention. Okay, so patent office didn't take any action. Okay, because Salvador is a new and patentable outside Egypt. So the original firm have to grant patent in Egypt. In case the original firm that didn't grant patent in Egypt, so they can give a permission or license to to the Egyptian factories to use or to make this.
Yeah.
But in this, the government have to take an action.
It took an action.
Yes.
We've seen a lot of brands recopied and replicated in the Far East, specifically in Egypt, in different countries, and we didn't see any objection from the original companies. Why is that?
Most of the companies take an action, but usually it is not. You see many counterfeit products in the market. in order to take a legal action, you have to provide documents which prove the infringement. Sometimes it is difficult to determine the source of the infringement products. You have to obtain the name of the infringer, the address, prove that these products are counterfeited, then file to a lawsuit, and you have to be sure that the products are still available. Sometimes you see a counterfeit product available in the street, so you can, the man who sells on the street can also sell you a counterfeit product, or for example a glass with a well-known trademark on it, but you can't take an action because you don't have a proof that from the source of these products.
Then it's something ethical from A to Z.
Yeah. Yes.
Yeah. And unfortunately, we cannot depend on that all the time.
Yes.
Whenever we're talking about
Yes.
money, it's money. Greed,
Yes.
I think it's found all over the world.
Yes.
It's not only in the Arab or the Middle East region,
Yes.
but it's all over the world. Mrs. Nadia Adey, Mrs. Mona Dagher, thank you very much for being with us. Have a very good day, and happy International Day of Intellectual
Thank you.
Property. We are going to leave you with the promise
Have
to
a
see you
good day.
again on Nile TV screen. Episode of The Breakfast Show.
Right, and with this we come to the end of this edition of The Breakfast Show. Stay tuned for more coming up here on Nile TV International.
And it's goodbye for now.